understand that historically, and I'm talking about pre-1989, there was no option of post-conviction relief in municipal court. It just didn't exist as something that could be raised on a post-conviction basis. There had always been post-conviction options in the Superior Court criminal part, and I guess as a matter of constitutional law that would have to occur because you all know that the post-conviction relief in New Jersey is the functional equivalent of the writ of habeas corpus, the so-called great writ, which is, although not constitutionally protected in our federal constitution, the procedure for it and the rules for suspending the writ of habeas corpus are set forth in the body of the Constitution. So this is a writ that's existed at the common law for, I don't know, at least 800 years and maybe longer. So it's of such importance it was covered in the Superior Court under Rule 3:22. Now the first mention that I'm aware of where the option of having post-conviction relief came up through Judge Haynes in the case of State versus Owczarski. So in Owczarski, Judge Haynes, were you involved in that case, John?
No.
No? I know you know Judge Haynes very well.
Judge Haynes very
he, for the first time, determined that it would be perfectly appropriate to have a procedure for post-conviction relief in the municipal courts, okay? But this is just a law division case, and it didn't really have any impact around the state. The impact came in State versus Laurick in 1990, the following year, where the New Jersey Supreme Court actually created the procedure of post-conviction relief in the municipal courts. But again, not created through a court rule, created it inside of the body of a case. Now, shortly after the Laurick decision came out, there was a case called State versus Gonzalez, again, another Judge Haynes sponsored catastrophe, where the Supreme Court had to make a determination as to whether or not police in the state had to have a probable cause determination made before they issued process on a traffic ticket, all right? And of course you can imagine this would have had a catastrophic impact on the way the police operating, having every time they read a ticket, even a parking ticket, having to have an independent judicial probable cause determination made. So the Supreme Court established the procedure where police can now make their own probable cause determinations. But in the body of the Gonzalez decision, they make a determination that the cross-references between the Part 7 rules and the Part 3 rules were really kind of causing some confusion. And they suggested that there should be a rewrite of Part 7 so that Part 7 would have its own independent rules. A court should relax 322's bar only under exceptional circumstances. The court should consider the extent and cause of delay. These are the factors, okay? Extent and cause of delay, prejudice to the state, and the importance of the petitioner's claim in determining whether there's been an injustice sufficient to relax the time limits. As we've made it clear, the longer the time spans since the original trial, the more difficult a retrial becomes. Absent compelling, extenuating circumstances, the burden of justifying a petition filed after the 5-year period will increase with the extent of the delay. The prejudice to the state's ability to litigate the case long after the delay is also relevant. You writing this down, Chris? If the key witnesses are unlikely to be available, evidence has disappeared, or other obstacles are present, allowing the petition for post-conviction relief will unduly prejudice the state's ability to bring its case. These concerns must, however, all the defense attorneys listen, be balanced against the significance of the petitioner's interest in raising his or her petition, in other words, going to jail. If the petitioner articulates facts that demonstrate a serious question about his or her guilt, this is what you're going to have to put in your petition, serious question about guilt, or propriety of a sentence imposed, which really doesn't matter because it doesn't have any time limit, it's a bad sentence, and is prepared to provide a factual evidence to support it, then sufficient grounds for relaxing the rule might exist. In other words, a court should determine that the procedural rule as applied is unjust only when a significant liberty interest is at stake and the petitioner has offered something more than a bare allegation that it is so. Because a bright line rule is impossible, a review of some of the cases which procedural bars have been relaxed may provide a better sense of what we mean. And I've given you a copy of the case in your materials so you'll see all those. When you look in the cases, you have State versus Mitchell in there. So this is kind of like the laundry list that you would rely upon when you're trying to get the rule relaxed to get around the 5-year bar, okay, assuming that it's not an illegal sentence, and assuming that you're not going to be able to support excusable neglect, which is also discussed in the Mitchell case. These are the factors that the judge has to weigh and evaluate when making that determination. Let's go through this, guys. Petition, this is number 3. Petition for post-conviction relief shall be the exclusive means of challenging a judgment of conviction except as otherwise required by the Constitution. But it is not a substitute for appeal from a conviction or a motion incident to the proceedings in the trial court and may not be filed while appellate review or filing of a motion in the municipal court is available. So you really got to be, number one, you can't do this while you're on appeal, first of all, because the municipal court doesn't have jurisdiction to hear your case in the first place. But assuming that you wanted to go back to another court, you're not allowed to do that while your direct appeal is going on, or that you're still in time to do motions in municipal court. Now, here are the grounds that you have to allege in your petition, okay? One, substantial denial in the conviction proceeding of the defendant's rights under the Constitution. This is where, again, you go back to effective assistance of counsel. This is why it becomes the quintessential basis for the petition, because you're obviously entitled to the effective assistance of counsel as a matter of the Sixth Amendment. All right? Now, number two, lack of jurisdiction. What you can do a lot of time is you can challenge either the trial level jurisdiction, in other words, that the judge made a determination on the case that was outside the jurisdiction of the municipal court. That's, these municipal courts are inferior courts. They're not constitutional courts, so their jurisdiction is set by statute. You just check 2B and Title 2B and see whether or not what the judge did was within the court's jurisdiction. The more fruitful argument lots of times is going to be territorial jurisdiction, that the offense took place outside the territorial jurisdiction of the court, okay? He was in Egg Harbor Township, sentenced there, but the trooper wrote the wrong ticket. You find out he was actually in Egg Harbor City, something of that nature, okay? That should be able to get you in the door based on the argument that the court didn't have was not within its territorial jurisdiction. Three, imposition of sentence in excess or otherwise not in accordance with the sentence authorized by law. That's the one I used for the Owczarski case. And here's the catch-all. Any ground previously available as a basis for collateral attack on a conviction by habeas corpus or any other common law or statutory remedy, okay?
That's your ineffective assistance of right to counsel.
All right. Let's see. We talked about this earlier. Defendant is barred from asserting in a proceeding under this rule any ground for relief not raised in a prior proceeding under this rule, or the proceeding resulting in conviction or a post-conviction proceeding brought or decided prior to the adoption of 322.4, or in an appeal taken proceedings unless the court on motion or hearing finds that, and this is what Murray would have had here, the grounds for relief not previously asserted could not reasonably have been raised in any prior proceeding. If you've gotten kicked out of court already on a 5-year deal, like Murray did on Laurick application, this will authorize you to go back in and refile your petition, because you have grounds that you could not have reasonably raised because the law hadn't been decided at that point. I want to just have you take a look at number 2 here, okay? Prior adjudication on the merits of any grounds for relief asserted in the petition is conclusive, whether made in proceedings resulting in conviction or in any post-conviction proceeding or any appeal taken from those proceedings. So basically number two means you can't collaterally attack the finding of guilt, for example, or the determination of an appeal or the determination of a post-conviction relief application in another court. You can't say, no, I was really guilty, you shouldn't look at that. They have to take these holdings and these judgments as you find them. You can't collaterally attack it here. All right, counsel. I'm not sure that many people here are going to be interested in this. Any public defenders here besides me? 1? All right, 2. Have you done any of these? Anybody walk into court and want the assignment of counsel? Under E? I actually got roped into one of these. I had to write a brief and everything. An enormous amount of time. I was so happy the judge denied him.